Good morning.
Glad to see you didn't have to commute.
Me too.
All right, you all set to go?
Yes, thank you.
Thank you very much. We are back on the record for the third day of this hearing in two consolidated cases. Court of Claims case 25-000143-MB and 25-000162-MB. First of all, I want to thank the attorneys for your diligence in getting to court this morning. I received the email about whether we were going to have court, and I have a relatively short drive in, so it was no challenge for me, but the roads were horrific. And the fact that you're all sitting here is a testament to your commitment to this case. Second of all, much more broadly, I want to thank everybody, all the attorneys who've been involved in this. This has been a very difficult ordeal on an extraordinarily condensed schedule we managed to get from beginning to end in this case. You're about to hand off the baton to me for the last leg of this, where I'm going to get the opinion to you that will, I think, finally resolve so many of the disputes we've been discussing. But the diligence and the professionalism you've displayed during the course of these proceedings is really, really impressive. I complimented all of you collectively yesterday, but I want to compliment each one of you. We worked out some more details yesterday. I guess I could probably call it the evening. It was after 5 o'clock when we sat down and talked. And I received an email last night indicating that there would be no more witnesses. That's obviously perfectly fine with me. I think then all that's left is to move into final arguments. And Ms. Service, from where you're sitting, I'm guessing that you're going to be speaking on behalf of the defendants. Is that accurate? All right, and at the other table, I'm not sure who's all going to be speaking. I see 4 of you lined up. Each one of you has played a major role in this hearing. Am I going to be hearing from 2 of you or more?
I will be speaking on behalf of the Region 10 plaintiffs, Your Honor.
All right, thank you very much, Mr. Marchand. Mr. Cook, I'm sure you're speaking on behalf of all the plaintiffs in the other case.
That's right.
All right, and so Mr. Ryan and Ms. Wixon, you're here as observers and ready to step in case you need to, right?
Yeah, we have a little housekeeping that I'll handle before the closings if it's okay, but.
Oh, sure, of course.
Just let me know.
All right, let me invite you then, Mr. Ryan, to tell me whatever you want to tell me, and we'll see what else we can take care of here.
Three quick things.
Sure. Would you mind pulling that mic in? Sure.
3 quick things all related to exhibits. Number 1 is, I think it's all the collective attorneys understanding that what the parties submitted and attached to their briefing is going to be considered by the court.
Sure, sure.
The second one is in terms of plaintiffs' exhibits, we had a lot of binders. I think we want, and I think there's a stipulation that we'll admit exhibits 1 through 31, which are all of the RFP, the attachments, the various amendments, everything posted to Sigma.
Correct.
Thank you. That's fine. So 1 through 31. Thank you.
And the last thing is related to the issue of the EQI reports and the admission on that. And I don't want to rehash all of this, but I do.
And just to put it in context, we're talking about Defendant's Exhibit A and the underlying documents.
Yeah, that's correct. So our position is that this summary was misleading at best, that it only used portions of the underlying documents, none of which have any foundation. We heard testimony that the summary was based on a tab 6 in those underlying documents. And again, we were never provided any spreadsheets that had tabs. So the rule 1006 was not complied with, and we think it shouldn't be admitted. We have no way to verify the accuracy of the summary. And more importantly, we believe it portrays a very inaccurate picture of the system. And our concern is, if admitted in this case, it will be used outside of the confines of this case in a way that it would inaccurately portray the system. So on the evidentiary issue, if the court is inclined to admit it, we would be happy to provide some supplemental briefing on that. As to the supplemental briefing, we'll leave that to the court's discretion, but I at least wanted to make the record and renew that objection.
That's fine.
Thank you.
Ms. Service, do you want to respond? You can do it from the table or from the lectern, wherever you like. Just to be clear, I mean, the document's already been admitted. It's just a question of whether I erroneously admitted it and I should overrule my prior decision. I'm perfectly satisfied that it's the sort of situation where a summary would be appropriate under Michigan Rule of Evidence 1006. I think Mr. Ryan's concern is not so much that as the provenance of the underlying documents, the EQI reports.
I'll respond very quickly to say that, of course, we support the court's admission of the exhibit into evidence. It does fit under Rule 1006. And just to clear up the record, what we provided plaintiff's counsel was tab 6. And so the version that they saw doesn't have a tab 6 because we extracted tab 6 itself, just to be clear.
All right. Well, what I'm going to do is I'm certainly not going to reverse myself now. I know almost nothing more than I knew when I decided to admit it. I'm certainly willing to take a supplemental brief from you if you want to submit it, Mr. Ryan. For what it's worth, I intend to give this very little weight. It involves mostly entities that aren't even parties to this litigation. And to the extent that it represents evidence that the parties to this litigation had remarkably higher costs than the providers who were not CMHSPs or PIHPs. I'm not really persuaded by the contents of this document, but if you want to try to somehow get me to change my mind, what you can do is file a motion for reconsideration on that. Obviously, you have 21 days to do that, but I'd prefer that it come in much sooner. And then, although the rule doesn't allow a response to a motion for reconsideration, if you want to respond, Ms. Service, you can. And so I promise I'll handle it in order. I'm intrigued by your somewhat cryptic comment that it may be used in other contexts. I'm not so sure what that would be. I can tell you it's certainly not going to be outcome determinative with regard to the motion for summary disposition that I have before me or the preliminary injunction request.
Thank you, Your Honor. And I didn't mean to be cryptic. It's just, we believe it is a very inaccurate portrayal.
Sure.
And if admitted, and some may interpret that as some sort of blessing as to its accuracy. And
All
I
right.
wouldn't want that misinterpretation. out
Right.
there.
Well, as I see it, I don't so much have a foundational problem. My problem is I don't want to assign much weight to it at all because, as you say, it is just a very tiny sliver of what would be a much larger practice of setting the rates for providers and setting the rates for CMHSPs and PIHPs to provide services. So,
Yeah, we will file a motion for reconsideration if we think it's appropriate, but I don't think it needs to hold up the court's ruling if Your Honor's not going to assign much weight to it anyway.
right. I can assure you that although I've reviewed it, it's highly unlikely to be cited in my opinion.
Thank you, Your Honor.
Okay. All right. Now, does that take care of everything prior to the closing arguments?
From our perspective, yeah.
All right, let me just offer some thoughts now. I know we had a discussion off the record yesterday, but I want to try to explain on the record where we left off yesterday, which I think occasioned the decision to drop witnesses going forward. As I see it, what I have in front of me primarily is a decision to make about the propriety of summary disposition under either MCR 2.116 C8 or C10 as requested by the defendants, and then the competing request for summary disposition under 2.116 I2 made by the plaintiffs. In addition, there of course is the separate issue about whether to grant injunctive relief. And I've indicated in a prior opinion, and I'll indicate again today, that my strong inclination, if I think relief is warranted, is merely to issue a declaratory judgment and then retain jurisdiction over the case in case I need to impose injunctive relief if they're out of compliance with what I've said in my declaratory judgment. So what we really need to focus on here, I think, even though there have been lots of issues discussed, and I know they're of great import to so many people across the state, what I think we need to discuss, though, is whether the RFP and the structure it would impose, I know it hasn't resulted in contracts yet, but the structure it would impose is either consonant with Michigan law or inconsistent with Michigan law. And then if it is inconsistent with Michigan law, what's the remedy, if any, that I should fashion in this case? Because I heard the testimony from Ms. Gove, and I think that this is really more a DTMB problem than it is an MDHHS problem, because I think that Ms. Osmond, for example, indicated when I asked her about the three categories Ms. Gove had described, that was something that was really the bailiwick of DTMB. So I think, as you might have guessed if you read my opinion in order resolving a request for summary disposition back on, get the date on that, I apologize, October 14th, 2025. What I forecasted we would have to do to get to a ruling on summary disposition is figure out whether this structure is inconsistent with Michigan law, particularly with regard to the CMHSPs, but also to the PIHPs. As I told you last night off the record, Ms. Service, I mean, you won a large portion of this case already, because I've already indicated I don't see anything in Michigan law that prohibits MDHHS from going from 10 PIHP regions to 3 PIHP regions, nor do I find anything in Michigan law that prohibits MDHHS to make the decision in its own discretion whether to go from the traditional single source procurement system to a competitive procurement system. But if we're going to do that, I think we have to do it in a way that honors the rights and responsibilities assigned to CMHSPs in particular, and PIHPs as well under Michigan law. So I invite you to pick it up from there. I will confess that I'm still murky on how DTMB deals with situations where you have problems about incompatibility between an RFP's terms and Michigan law. So anything you can tell me to educate me how I should look at that would be really helpful. Thank you very much. By the way, you'll each get 2 rounds. I want to make sure everybody has an opportunity to make their arguments in response to whatever anybody else has to say. Okay, thank you very much, Ms. Service.
Thank you, Your Honor, and thank you for the court's time, and thank you to the strong advocacy on both sides of this case, as there's been a lot of that.
This case was extraordinarily well litigated by everyone.
Thank you. So I'd like to go back to how I started this hearing in the opening, which is to talk about the state's position on the interplay between the mental health code and Medicaid managed care requirements. In the state's perspective, those are 2 completely separate frameworks, almost in 2 separate columns, as opposed to the concentric circle analysis that plaintiffs use. There's several reasons why they have to be 2 separate frameworks. The first is the timing of when the legislature enacted the mental health code provisions at issue, and then later when Medicaid managed care came to the scene. And we have to assume that the legislature did not intend for there to be a conflict. In other words, we have to find a harmonious reading.
Right. To the extent that I can harmonize 2 statutory schemes, I'm required to do so.
Correct. And we think there's a very easy way to harmonize, which is to look at the managed care functions as completely different than the CMHSP's managed care functions that they're currently conducting. And we can do that by looking at the language of the mental health code itself. 330.11162B talks about CMHSPs doing direct delivery of services. We can't look at the word direct as surplusage. Of course, we know the rule of statutory construction. So to us, direct delivery means that is what they are doing, is delivering services, not being essentially like a mini Medicaid managed care entity.
Okay, so stop for just a second. I think, and I was talking to the senior research attorney from the Court of Claims who was working on this morning. I think you have reached the point where you agree that CMHSPs can continue to act as providers, direct providers of services, but they really can't do anything more than that, to the extent that they built these webs of providers and they set up networks so that they could refer people out to other places. I think the position of the state is, well, they can enter into non-financial contracts, but not financial contracts.
You got it exactly. We heard testimony Monday from a CMHSP witness that talked about having a managed care arm and a service provider arm. So it's that managed care arm that really is in conflict here with the statutes, because the statutes talk about CMHSPs providing services. And the other statute is 330.1206, again, talks about delivery of services.
Well, let me stop you for a second and let's talk about specific instances that were highlighted by the plaintiffs. So I think it's pretty clear under Michigan law that a CMHSP has to have a recipient rights office, right? Or at least a recipient rights officer.
They absolutely do. And
Presumably that's to serve some sort of oversight function, right?
it's to make sure that beneficiaries' rights are protected. The mental health code has a list of rights that all recipients of public mental health services are entitled to. Right to be free from abuse and neglect type things. And so that's the function of recipient rights offices.
Okay, so stop for just a second then. Is it your position that they're wrong when they say they can't engage in that sort of oversight unless they have financial contracts? Or on the other hand, is it your position that it's just not their job to do that?
It's our position that the RFP does not affect what statutorily CMHSPs do for recipient rights. In other words, the non-delegation function of the RFP does not include recipient rights because that's not a Medicaid managed care function. That's a statutory function.
So would they then pay for the oversight work they do under general funds, or would it be something else?
Yes, and that's how it works now, is my understanding.
Okay, okay, I understand. All right. And I'll ask you about some of the other examples, but I want to give you a chance to make your argument.
Sure. So back to that two separate frameworks. Another reason that it has to be the case that they're two completely separate frameworks is because both the Social Welfare Act and the Mental Health Code give DHHS broad authority to administer the Medicaid program and public mental health services. And so to the extent that there is a conflict, we say there's not, but to the extent there is, we have to look at the broad authority and say, if something doesn't fit between Medicaid managed care and the mental health code, it doesn't need to fit because they're two separate frameworks. So the CMHSPs have their responsibilities under the mental health code. If there's some Medicaid managed care function that's different, that's okay because the CMHSPs are still conducting their statutory responsibilities under the general fund. Medicaid managed care is completely separate and outside of that.
Okay, well, we've heard a fair bit during the course of this hearing about how CMHSPs really can't manage their administrative costs without using Medicaid funds, and whether you call it braided funding or whatever you call it, if they're limited to general fund dollars, they're not going to be able to maintain the structure that Michigan law requires them to maintain. They have to have, I think, a psychiatrist and some other people. Anyway, there are certainly costs, administrative costs associated with running a CMHSP. Is it your view that those administrative costs can't or shouldn't be covered by Medicaid funds?
So administrative costs should be covered by whatever it is, that two things. They are allowed to keep some administrative cost under Medicaid managed care. That is a thing. They also, have their general fund contract. To the extent that they're saying they can't use their managed care arm, that is perhaps the issue here because the state says they shouldn't be doing Medicaid managed care in the first place. So there are statutory functions under the mental health code. We heard Ms. Asman testify yesterday. DHHS knows that they still have a responsibility to make CMHSPs the primary entities responsible for the direct delivery of services.
But as a provider.
As a provider and not a manager of those services, not performing the administrative functions to have those services be provided.
Right. As I understand it, the purse strings now for the Medicaid managed care system are entirely in the hands of the PIHPs. They will be under the RFP.
Yes, because the Medicaid managed care entities, the PIHPs under the RFP would be responsible for payor functions, and that does that separation so that CMHSPs are not setting their own rates, that they pay themselves for the same
Right.
services.
And I get that. That conflict, I think, is manifest, and I understand the problem. And I think you may even be concerned about the federal implications of that.
We're concerned about the federal implications. I'm not standing here today saying CMS has said you must change your system right now, but there's been testimony that there's been general concerns. And so, of course, the state's thinking about that. In terms of the substance abuse services,
I think it's the SUD.
the SUD, yes.
I mean,
SUD.
substance abuse services might be a more logical way to say it, but the acronym
Yes,
picks up SUD, which substance use.
yes, yes, that's right.
Why, I don't know, but go ahead. I understand. We're on the same page.
Yes, so as our briefing detailed, couple things. First, nothing in the RFP actually says that the new PIHPs must be that community mental health entity. That's that term, the department designated community mental health entity. That's
Right. In other
concentration.
words, something that comes from the grassroots, if you will, where the CMHSPs band together and essentially create the PIHP.
So this one's a little different. On specific to SUD services, there's this term, department designated community mental health entity.
Right.
So plaintiffs are looking at the definition of that term in the mental health code, which does limit that to being CMHSPs or CMHSP regional entities. So not to put words in their mouth, but my understanding of their argument is, well, the new PIHPs cannot be the CMHE, and therefore the RFP fails. So to that, first of all, the RFP does not say that the PIHPs have to be the CMHE. But even more importantly, the mental health code actually says the definitions in the mental health code apply unless context requires otherwise. And so here, context does require otherwise for defining what this department designated CMHE is. Because for these particular small subset of SUD services, I know there's been testimony that SUD is funded a lot of different ways, but for Medicaid funded SUD services, context does require otherwise. Because now we're in a system, a completely different framework, the Medicaid managed care framework, totally separate from the general fund responsibilities that CMHSPs have.
Okay. Well, and I don't mean to take you off SUDs if you want to talk about that some more, but if you don't mind, talk to me about the involuntary commitment problem. I think you use a different term for it, but to me, that seems to be one of those areas where you have somebody showing up at a CMHSP and necessarily they have to engage other providers. There's no way to provide for involuntary commitment unless they can deal directly with hospitals. And I mean, they need to get certifications. It's a very quick process. So walk me through that and explain why the RFP doesn't create a problem for CMHSPs in dealing with involuntary commitment.
The RFP makes one exception to the non-delegable Medicaid managed care responsibilities. And that exception is for pre-admission screening for hospitalization. So that's any functions of pre-admission screening unit under, there's a specific statute in the RFP 1409. All of those functions can be delegated down in a managed care capacity to the CMHSP. So the state's position is nothing should be changing about civil admissions. And taking Ms. Asman's testimony from yesterday, two things. One, CMHSPs under their statutory general fund responsibilities would still have the hospital contracts and things of that nature. But then second, if it wasn't a Medicaid managed care contract, a payer type contract, and it was just some other sort of arrangement, which does
happen. Are you talking about a non-financial contract?
Yes, a non-financial contract.
Is that something that exists? I mean, it seems odd because everybody knows in order to form a contract, you need consideration. What's the consideration in a non-financial contract?
Yeah, I mean, and that's a great question. My understanding is there are kind of arrangements like that throughout public mental health. I don't have a specific example off the top of my head, but I think it makes sense because if we're looking at Medicaid managed care, we're thinking of like who's paying what for Medicaid, who's looking at the contracts for Medicaid, who's doing compliance.
Right.
That can be separate from the CMHSPs and their duties to actually run the services. I totally get the court's question about that.
I mean, it's almost as if these CMHSPs have to go around in the hospitals with a bag of peppercorns, handing them out so they've got consideration. I mean, that seems like a really odd way to form contracts.
I totally understand. And I think part of that is this is all hypothetical at this point because we don't know who will win the bids. And we heard Ms. Asman say like to operationalize it, they are used to operationalizing things when things are handed down to them from the federal government or whomever, like this is what you have to do. They figure out a contracting way around it.
Well, and can I talk to you about that for just a second? Because now I want to talk about the PIHPs for just a moment. Because I think we agree that the PIHPs, the 10 existing PIHPs, are eligible to bid on the contracts specifically because they don't provide services across any of the new 3 regions, right?
As their current geographic boundaries are currently correct.
Right. But what I think I heard during the course of this is that for each region, there's some expectation there may be more than one PIHP, right?
That's definitely a possibility.
So let's say that you have one of the new regions and the boundaries of that new region are coterminous with the boundaries of a collection of PIHPs who exist today. Can those PIHPs band together and bid, or must they do it individually and then necessarily be disqualified because their coverage isn't across the entire region?
As long as the bidders meet those kind of minimum requirements, the geography being one.
Right, but what if they meet it collectively but not individually?
So you're saying if it was,
But let's say that we've got, of the old 10 regions, regions 4, 5, and 6 line up with the boundaries of a new region 2. Can the PIHPs representing the current regions 4, 5, and 6 band together and bid to be the collective PIHPs covering region 2?
yes, they could band together as long as they do whatever they need to do legally. In other words, I don't think that they could say, we're 3 separate entities still, and we're putting in one bid. I think they would have to do some sort of urban cooperation act, and we heard Mr. Johnston yesterday say that's a quick process, kind of a paperwork type thing. So I think they would have to form something.
All right, so it'd be a new entity, but
Yes,
it would be an entity that consists of 3 existing PIHPs.
that's exactly right. Or a conglomeration of CMHSPs who form a new regional entity. I mean, there are possibilities that all of the players in the current system could reconfigure, that's our expectation, could reconfigure to meet the geographic requirements.
Okay, now let's talk about universities, for example, being PIHPs, because obviously 1 or 2 come to mind as potential players in this field where that university could essentially be the PIHP for the region. In that circumstance, we heard a lot from the other side about how they would be disqualified from providing certain services that are necessary under the Medicaid system. Do you disagree with that?
What universities are disqualified from is receiving substance abuse block grants.
Right.
So that certainly could be an issue that would need to be dealt with. Whether it's dealt with by having another PIHP in that region that can receive SUD block grants, and for SUD services, that would be the PIHP that the beneficiaries would go to.
But what would that PIHP have to be? Would it have to be one of these multi-CMHSP entities, or would it have to be something else? Or could it be something else? I'm sorry, it wouldn't have to be, because I think we all agree that when these CMHSPs band together to form a PIHP, that PIHP can handle those funds, right? Those Medicaid funds.
That's right.
What other sort of potential PIHP could handle those sorts of Medicaid funds?
The only other potential type of bidder is a nonprofit, and to be honest, I don't know, and I'm happy to submit supplemental briefing if the court wants, but on if nonprofits can receive SUD services, unfortunately, I
Okay.
just don't know.
Okay, that's fine. Thank you. And believe me, I think we're all feeling our way here. There are a lot of difficult questions. So go ahead.
Thank
Go ahead
you.
and take over again. I'm sorry.
You mentioned earlier the braided funding, and that's that concern that a beneficiary might have multiple funding streams that funds it.
Right. And I think we heard that that's commonplace.
That's what I was just going to point out as Ms. Asman testified. That does happen across CMHSPs now. So our position is that lessens any concern about that. And I guess, so I think that covers like the group of services. Before I move on, does the court have any other questions about like the specific types of services?
No, I marked a whole bunch of different services that we're going to have to talk about in the opinion, but I don't want you to go through each one. I mean, I'm going to do the best I can in the next round to come back to you on that, because I have a feeling that in particular, Mr. Cook's going to identify all kinds of things that CMHSPs are not going to be able to do. So why don't you go ahead and move on to the next subject, and I promise I'll ask those questions when you're on your feet the next time.
Okay. The court has heard testimony from many different people throughout the course of this hearing. And a lot of the testimony at this point is concerns about the practicalities of operationalizing this. And as I pointed out at the beginning, we agree with the court that honestly, this is really a legal issue. So the best place to go for the legal dispute would be the parties briefing and not thinking about witnesses that, testified about concerns.
Well, right. And I think, to your point, I think one of the main concerns they've identified is it's going to be impossible for a new PIHP to replicate the network of providers that they've set up. And I don't think that's really the right question whether we're trying to figure out whether it conforms to Michigan law, because you envision a whole different system where the PIHPs control the funds and they have the financial contracts. And so they won't be trying to replicate the existing CMHSP networks. They may be using a lot of the same providers, but it's not like they have to go down to ground level in each county and replicate it. They're going to have to line up providers, but I think that's part of the competitive procurement system that you won't have a go-to provider for certain services. Yes?
Yes. And going back to the testimony of Ms. Sork, she testified that sometimes they have to go out of their county. They're a smaller, more rural county.
Sure.
If there were, I hate to use the term mega regions, but if there were these bigger PIHPs with bigger regional footprint, they would have the buying power to have more of these in-network providers all housed underneath them. So the state's hoping that actually makes administrative efficiencies better, because they don't have to say, well, this is our provider network, and then go to one of the other 45 CMHs and say, well, who's in your provider network and can we use them?
Just to give you an example, back to involuntary commitments. I mean, presumably there would be a hospital system that in each one of the three regions that could provide full services for involuntary commitment candidates.
That would be my expectation, yes.
Right, because as I understand it right now, I mean, you have hubs where a lot of the involuntarily committed recipients wind up. Grand Rapids, for example, is one where we have a disproportionate number of involuntary committees, and as a result of that, you have a lot of people reaching out to the Grand Rapids facilities, right? But if you have just three mega regions, as you describe them, if Ann Arbor's in one and Grand Rapids is in another and Lansing's in a third, I haven't looked at the maps lately, but I mean, presumably what you're explaining would be that you'd never have to go out of region to get those specialized services. You'd have providers available in the region.
That's absolutely the hope, rather than fragmenting it so much and fragmenting all of those managed care functions across really 10 PIHPs and 46 CMHs. Now, all of that is done in 3 regions of the state, and it makes it more administratively efficient across the state.
Right. I mean, I think the broader concern that they would raise to respond to that is there's no doubt that you're going to have less duplication of administrative services under this model that you're going to. And presumably with competitive procurement, you may be able to drive prices down. But I think what they would say is there's a local component that's essential here, because if a recipient goes in and is suffering a mental health crisis, I mean, it's not the sort of person you can expect to shop for services. I mean, they need to go to one point of contact and be able to take care of everything, right?
I definitely heard the testimony on that and I took that seriously. What I would come back to is that is one of those non-delegable functions that pre-admission screening still can be delegated to the CMHSPs. And I think that's why. That's a very important function.
Okay, go ahead.
We heard Ms. Asman testify that kind of along those same terms we've just been talking about, the state's intent here was to strengthen CMHSP's statutory functions. So as I've just been talking about, the CMHSPs, their function under the statute is to be a provider. And at requiring the new PIHPs to contract with the CMHSPs, it's the state's position that that actually strengthens the CMHSPs and what they're working on. We also heard Ms. Asman testify that the state did not intend to violate any term of the mental health code. We heard her say that they looked at the law, they did not intend for any particular term to be violated.
Right, I don't doubt that at all, but the question is whether intentionally or inadvertently they're out of, that the structure is out of compliance with state law, then I have to provide some measure of relief. And I expect where you're going eventually is remedy, and I'm hoping you can get there sooner rather than later.
Yeah.
Because if some aspect of the architecture designed by the RFP is out of compliance with Michigan law, it doesn't necessarily mean that the whole RFP gets blown up, the bidding, you have to issue a new one, the bidding process starts again. That my takeaway from Ms. Gove's testimony is that there are gradations of problems. And with 2 of the 3 gradations, you don't just blow up the process and start all over again.
Yes. So the request that the state would make of the court is, to the extent it's possible, to identify which particular terms of the RFP, if any, the court does not believe conform with Michigan law. I think that would be so helpful for a lot of reasons. First of all, it would be helpful to the state to know what to do. Is that a situation where we can do some sort of correction notice, or is that a situation where the RFP has to be pulled and they have to just completely start from scratch?
Because you did point out, and I think this is worth noting, there's a severability clause in the RFP. I mean, you write a document that long, obviously, there's a possibility that something will be declared aberrant, and it can't be the case that any slight defect requires you to go back to square one, right?
Absolutely, because we have to think of this, that we have this kind of deadline, the September 30th of 2026
Right.
deadline.
Right. I mean, you built in, when you first started this process, what you thought was going to be a year. And if it gets compressed to 6 months, it puts more pressure on everybody to get this built. And if it compresses down to 3 months, that's an even bigger problem, and I get that.
And if the court's opinion says there, there's all of these very specific things in the RFP that don't align with Michigan law, then it will be up to the state in their statutory discretion to run procurements, to run the Medicaid program, to decide what to do. The thing I would flag is it's possible we could be, no matter what the state does, if they issue a change, if they pull it and issue a new RFP, it's possible we could be back in a cycle of litigation again, which would just keep delaying that.
You read my mind, because it seems to me that if I do what I say I'm going to do, which is limit myself to a declaratory judgment, not an injunction, the case remains open, because I would say there are genuine issues of material fact. So I'd have continuing jurisdiction. And then I suppose they could come back and argue that you're refusing to comply with the declaratory judgment. And so now I should drop the hammer and impose an injunction. That's something that I would much rather not do, not just because judicial modesty prevents me from ordering state agencies to do things by injunction unless I absolutely have to, but also because we're wasting time when we do that. So if my inclination is to let MDHHS and DTMB figure out whether this requires, after I identify what I believe to be defects or nonconformity, I guess, what I would prefer to do is have DTMB decide whether this requires a pullback or whether a change is all that's necessary, for example, excising provisions, whatever the case may be. I take it that would be your preferred remedy too.
That would be.
Leave it up to the discretion of DTMB to do what they think is appropriate under the circumstance.
Exactly right. We'll take what you say. And as we talked about before, I've never seen a situation where a state agency has a declaratory judgment and just, thumbs its nose at it. So we would take what you say and take, a very careful look at that. DTMB, DHHS would work together, I assume, to take a very careful look at that. But what we don't want to see is if this case goes away entirely, you issue a final ruling, the case goes away, and then DHHS and DTMB are scrambling, they get something else released, and then plaintiffs file a new lawsuit, and we're back at square one with a lawsuit that could take months and months, potentially with a judge who has no history with this.
Right. And that's why my determination here is to try to retain jurisdiction over it, because I'm realistic enough to know it's going to be very difficult for anybody to get timely appellate relief.
True.
And in some ways, it's better to come back to me and at least try to get me to deal with the problems as they arise, rather than trying to go to the Court of Appeals when things are changing on the ground as it happens. And I certainly don't want to tie your hands so that if they appeal, I can't do anything for you. The Court of Appeals can't get to it right away, and you need to get something out.
That's right, because in the end, all of this is about beneficiaries. Both sides have very different views on how that gets done and how to protect beneficiaries, but that's really the goal here, is to try to get something in place that protects them when that transition clause
And let me
ends.
ask you this, is it really the doomsday scenario if we get to the end of this current fiscal year and there are not yet contracts with PIHPs for the 3 regions? Because I know they're probably going to tell me that they have this continuity of care, whatever the term that people use for it, where they continue on as they are doing right now, right? I mean, as I understand it, the PIHPs for the 10 regions are still, even though you're locked in a disagreement with them over all sorts of things, they're still providing services, right?
They are, because under the FY24 contract, there was that 2-year transition clause that said the state could essentially require the contractors to keep performing services for 2 years. And that's what expires on September 30th of 2026.
Right.
Yes.
Right. Okay. So in some ways, I guess it is the doomsday scenario, because you lose the ability to require continuity of services, right?
We lose that, and probably more importantly, federal regulations require federal Medicaid monies to flow through contracts. So
Right.
I have a feeling that plaintiffs will say, well, we're willing to extend that 2-year transition clause for another period of time.
Right.
And obviously, that's something we'll have to explore. That just came up in the course of this litigation right before the last
Right.
hearing. So.
Right. I mean, obviously, parties to a contract can, on a bilateral basis, amend the terms of the contract.
Sure.
Can't unilaterally do it, obviously. So you can't do it to impose obligations on them continuing past the end of this fiscal year, nor can they insist that they can continue on, right?
That's right.
As the contracts are written today, everything stops at the end of this fiscal year
You got it.
and the relationships end.
Yes.
Okay, that helps a lot.
Unless the court has any other questions, I'm all set for now.
No, I'm sure I'll have more questions for you when you come up the next time, but let's give everybody else a chance to say what they have to say, and we'll
Thank you.
see where it takes us. Thank you so much. Mr. Marchand.
Good morning, Your Honor. The court correctly identified the 2 issues in front of it right now. Whether the RFP violates Michigan law, and if so, what to do about it. We could spend hours talking about the various iterations by which the RFP violates Michigan law. But at its core, all of that boils down to, almost all of it boils down to the managed care functions under the RFP. And the state's operating under 2 false assumptions. The first false assumption is in 109F. They said the PIHPs can only manage, they can't deliver. 400.109F allows for both. The second false assumption is that 1116.2B says they'll only deliver mental health services. But that's not the case. They deliver through a system We can't cherry pick the language out and leave out the rest of the system. They deliver through a system, and that system requires the ability to contract for the delivery of Medicaid behavioral health services. Because as we heard throughout the testimony over the last 2 days, you need multiple providers in an area to have an adequate system. If one provider fails or isn't doing things right, you need to be able to bring the person in-house quickly.
Well, let me ask you this, because it seems to me that the CMHSPs are much closer to the providers in their local communities. I get that.
Yep.
But do I have to assume that these mega region PIHPs couldn't replicate that or try to replicate that by entering into contracts with all these local providers?
Any effort by them to do so would violate the mental health code as it relates to the delivery of those services. And that's because we cannot neatly separate an individual into their insurance bucket. You know, take the example of specialized residential services under 1309. That's a per diem billable code. You get one shot to bill it. So in any situation, first, 1309 requires the CMH to establish and administer that entire program. And that program under 1226 is approved by the board of the CMH.
And just to be clear about that, this suggestion of non-financial contracts is just not a way to manage that problem.
Correct. There's no way to manage a system if you don't have the money. And we can go through any iteration, and I'll talk about inpatient in a second. But under specialized residential, just as an example, the CMHSP has the obligation to establish and administer an entire program of services. That requires the ability to spend the money, because you have to determine who is in and who is not in that program. And that's at the CMH level.
And I take it that your position is that having a CMHSP simply serve as a provider and nothing more than that is incompatible with Michigan law. If you think that, tell me why.
That is absolutely true. And we can go through any number of statutory citations where it says the CMHSP has to have someone under contract. Someone under contract. You can't have a contract without consideration.
Right, because first of all, you have to staff an office. I mean, whether you're talking about recipient rights or you're talking about having a psychiatrist or any of the necessary professionals, there have to be financial contracts, right?
Absolutely, Your Honor, because you can't pay for services if you don't have the money and if you don't control the money. And what we know from the very core architecture of this RFP is a couple things. One, the scope says that the new PIHP is supposed to provide a comprehensive array of mental health and SUD services in their new mega region. That's not coincidental language. That is language lifted from 1206 and 1210. 1206 is the statutory obligations of the CMH. 1210 relates to their obligations as it is for SUD services.
Right, because it sounds to me like what they anticipate is a Medicaid managed care system where the CMHSPs serve only as providers and the PIHPs essentially have to step into all these local regions and form this web of providers.
Correct. And that's
your view is not only is that impractical, maybe even impossible, but it's also incompatible with Michigan law.
absolutely, Your Honor. And it goes directly contrary to the core pillars that the state espoused in its RFP. They said that they're supposed to reduce administrative burden. So adding a fourth layer of, okay, we're going to have a new PIHP and then maybe a conglomeration of regional entities to do SUD services and then a CMHSP, that goes against their core pillar.
Well, stop for just a second. What do you make of their argument that it's a conflict for a CMHSP to be both a provider and a payer? Because obviously it's at arm's length with the providers, the other providers, but insofar as it's serving as a provider as well, there's no arm's length at all. I mean, they're essentially paying themselves, right?
They are paying themselves for services, but there's two issues here. One is that these are public entities with special protection. So not a regular governmental entity. This is a special public entity that has to cost settle. They don't get to keep any extra money. They don't get to charge extra like a private healthcare provider or a nonprofit or a university and say, we're going to jack up our rates to be able to make a profit on this and then carry that money forward. Whatever their cost is for the service, they pass on direct. And at the end of the year, that's settled out, and if they have extra money, it goes back. They can retain 5% of any excess, but then for unearned income, and that it has to be first applied in the next year. If they don't spend that in the next fiscal year, they lose it, and it goes back to the state.
Well, and just to be clear about this, I mean, I think the CMHSPs take the position that Medicaid dollars can provide support for administrative services, right?
Absolutely. And that is standard cost allocation of what are the fair things to include. And there are a whole host of administrative things that everyone has already agreed on is fair to use and fair to charge and allocate as part of a cost of any service.
Are you taking the position then that this alleged conflict with the CMHSP serving as both payer and provider is a red herring? Or it's just so commonplace that it's well understood that this is an appropriate relationship?
I think red herring would be the nice phrasing, Your Honor. So we had testimony from Jacqueline Coleman that CMS has not raised this issue. The CMS waiver renewed. And so conflict-free access and planning has been addressed, and CMS has not had any additional concerns. And the difference here, it goes to the second point. The state's argument almost assumes that the state has been violating its own laws for the last several decades. And so to raise it now that a managed care system has this conflict when they've been doing this for years is a little perplexing. And so this isn't the conflict that they're talking about. And even within the CMHs, as we heard Sandra Lindsay testify, their compliance and their rights and their audit departments are completely walled off. Those departments have completely separate staff, which is entirely consistent with the framework in Exhibit J to the state's response brief that says when you're having a conflict-free access and planning, particularly in a rural area where there's no other providers, you just wall off the staff. And you can obtain that exception as the state has done for decades.
But it certainly would be the case that if we have these PIHPs for these mega regions, that they wouldn't have any conflict at all. In other words, the PIHPs never serve as providers, right? They're always payers and nothing else.
I wouldn't say they wouldn't have any conflict at all. We're just introducing a different conflict because under the RFP, when you go to the risk corridor under Section V, what you have is a financial incentive for a couple things here. For the PIHP to deny claims to hit the medical loss ratio. Because what we know about the non-delegable managed care functions is that not only does it include payer responsibilities, it also includes utilization management. And a key component of utilization management is authorization of services and whether the service being authorized is the most cost-effective service.
Right.
So
let me just make sure I understand this, because the current funding system is that capitated funding system where
Correct.
essentially you get an allocation, it comes in at the front end, everything else is sorted out on the back end, but the money flows. Your view of what they want to do now is essentially put the PIHPs exclusively in charge of the flow of funds and allow them to turn off the faucet at times if they, I mean, you ascribe potential bad motives to them, but in the event that they believe that they're paying too much or they shouldn't be paying for certain services. So you're moving in a very different direction where the CMHSPs are completely at the mercy of the PIHPs.
absolutely, Your Honor. And they're at the mercy for organizations that can retain the profit. The nonprofits, the public universities, and public entities other than the CMHs and the regional entities they form, all of those structures can retain excess funds going forward. CMHs and regional entities cannot. And so that's the issue with their risk corridor now. Their local funds are not enough to cover all of their statutory obligations under the mental health
And I
code.
think Ms. Service talked about using general funds to cover administrative expenses. I take it your view is that the general fund money is so limited that you really couldn't even begin to run a CMHSP.
That's absolutely the case. And for the last 23 years, the state has taken the general fund money from the CMHs and reduced it. And I believe in 2014, the reduction was something like 60 to 70%. And they've taken that money to meet the state's obligation under the federal match to draw down more Medicaid money. Because at that time, everyone was working together to deliver the services in the best way possible. And that was draw down additional federal Medicaid money so that we can deliver more services to more people. Because when that person walks into the emergency room, you may not know their name. You don't know who their insurance, who has their insurance or anything else. Right. And so you need to deliver the service in real time.
Right. I mean, the most obvious example of that is somebody who's a candidate for involuntary commitment. I mean, you can't count on what they report in terms of their sources of funding or anything like that. That's somebody who's in crisis.
Correct. That someone's in crisis, and the non-delegable managed care functions violate even that process. Because while the while the RFP delegates under 1409, which relates to adults, there's a whole separate provision of the code and a separate subchapter of 4 relating to kids. That's 1498E. Relates to children. And there's a separate screening process and authorization for when a child needs to go inpatient. Because there's not an involuntary process for a child. We have their parents or their guardians. And so that process is entirely different and no longer delegated to the CMHs. And so this is where, when we're looking at these core functions, the very architecture of the RFP, Ms. Morningstar testified, non-delegable functions, that is the key architecture. She's the captain of the ship in organizing all of this. And these functions are core to the RFP. And so if any one of them violates the mental health code, and we believe there's a whole host that do, that goes to the very essence of the scope of the agreement, which is where we get to remedy.
Right. And I was hoping you were going to go there next, because it seems to me you don't have to convince me that there are 1,000 instances of nonconformity. Several is enough, in my view, to at least trigger consideration of how to address that problem then, right?
Yep. And so in how you address it, Ms. Gove testified there's really 4 options, but there's only 2 that apply here. So I'm going to first address the 2 that can't apply.
Thank you.
Just to kind of weed out, the noise. The first one is amending the RFP for the procurement. That only applies until the bidding deadline. The state exercised that option 5 times in this RFP. And we're on the 5th amendment, but that's no more. The other option is amending the contract. That happens after a contract exists, and there aren't any contracts, and the state can't issue an illegal contract.
Right. And my understanding of that is, when I identified the 3 that Ms. Gove had described, I didn't include that one because there's no factual predicate for that sort of
Correct.
remedy.
So now what we have is the remedy of a notice of deficiency or pulling the RFP. And Ms. Gove testified that the notice of deficiency is a limited remedy. She said that that is to correct little issues in the RFP. Let's take the where found model. It's within the scope of the RFP is what she testified is the notice of deficiency. And the scope is to provide all these services with non-delegable managed care functions. So the where found model, if you just struck that, it doesn't impact the architecture of the RFP. It's, maybe 4 paragraphs on page, 108 or whatever, that's gone. That's a notice of deficiency. That's equivalent to the amendments that they did 5 times.
Right.
But just after the bidding deadline. And the only people or entities that are eligible to address that are the existing bidders. The other is when is pulling the RFP.
Right. I
And
think
that's
she
the
described it as pullback. I don't know whether that's an
Pullback.
official term or an informal term, but yes.
My understanding is that's an informal, because I think my understanding of the policy procurement manual is that you would pull the existing one back and reissue. You would effectively start from scratch.
Okay, well, help me with pullback a little
Yeah.
bit then, because first of all, I certainly don't have any expertise in defining what's a serious enough nonconformity to require a pullback. And second, even if I did, I'm not sure that that's the best way to handle the situation when there's some quantum of defect that triggers that obligation, but DTMB typically makes that determination. What would be wrong with me identifying these flaws and then retaining jurisdiction and telling them, okay, figure out what to do about this? Now, I know what you're going to say. They almost certainly won't choose to pull it back, and then you'll be back in front of me saying they can't do this.
And, you know, I will take the state at its word that they will comply with your orders. And so what I would say is I understand the court's reluctance to kind of impose its own view when an executive agency has discretion.
Right.
But we do know from Ms. Gove a couple things. A pullback, as she referred to it, is where the changes to the RFP are outside the scope. We have the scope on page 3 of the Schedule A statement of work. And that not only says the comprehensive array of mental health and SUD services, in other words, the CMH's obligations under 1206 and 1210, that's the scope of the RFP for what the new PIHP is supposed to do. We also know from the general requirements about these non-delegable functions that are the very core of it. And so when those things are identified as the foundational flaws, our view is that there's only one remedy. And I think the court can identify the issues and say, here are the issues, and leave it to the executive agency to actually exercise that discretion. And if they don't, then we can come back.
Right, because I wonder, among other things, who really are the aggrieved parties if I strike provisions of the RFP. I mean, are your clients the aggrieved parties, or are the bidders, PIHP bidders, the ones who are the aggrieved parties? Because presumably, if we start tinkering with the architecture of the RFP, the consequences felt in the first instance by the new PIHPs in the super regions, who are now being asked to do either a lot more or a lot less than they thought they were supposed to do when they submitted their bids. It trickles down, of course, to the CMHSPs, because to some degree, the responsibilities are complementary. The more the super region PIHPs take on, the less the CMHSPs take on, and vice versa, right?
Right, they're both aggrieved parties in this instance. And I would say that striking these foundational things, my view is that we know there's large healthcare organizations who are interested who didn't submit a bid. Okay, I'm not going to go through the names. I know them. But what we do know also is that if there's anything other than starting the process again from scratch, DTMB in the state faces the possibility of additional litigation from entities that didn't bid because they found the existing architecture and structure unworkable. And now they're saying, hey, we didn't get a fair chance, because the whole point of a procurement process is to ensure that that procurement vehicle is valid. And our vehicle hit a big pothole. And so what we have is really one choice. But throughout history, the CMHs, both sides of this case, we're all committed to the beneficiaries and the recipients of this system. We remain willing and eager for the state to re-engage in discussions, because we want to solve problems too. We want to get it right. And so we're happy. The court could retain jurisdiction on the how. Order the parties to mediation or a settlement conference. You know,
But how does mediation work in a context like this? Because ordinarily, I like to see things worked out rather than battled out in court with me rendering some sort of determination. But if there's mediation, there are a lot of parties who need to be present who aren't present in this litigation. I mean, all the bidders for the new PIHP mega regions aren't included then, right? So that's a fundamental flaw in any sort of mediation model.
I agree that it would be an atypical mediation. And so it would require both the parties and the court to be creative in the process. But there's a way to do it. And I think that way can be accomplished because it's not just the parties in this room. There's a lot of parties out there who want to have an input on the process and input in what this ultimately looks like. And those organizations would also presumably need to be involved to try and negotiate, okay, how do we do this?
Right, but that sounds almost more like notice and comment than mediation. Because it's a zero sum game, right? I mean, whether it's 6 billion or 6.2 billion or whatever, I mean, it's gonna flow down through PIHPs to CMHSPs and providers, right?
Right, and under this existing system,
There's no win-win outcome here.
but under the existing system, as they set the RFP up, only the CMHs and regional entities are eligible. And here's why. 10B under SUD services for the services, I believe that's section N of the RFP. Service number 10 is SUD services, and subsection B requires any bidder that submits a bid to comply with all parts of chapter 2A of the mental health code.
Well, right. I get that, but I mean, their solution is multiple PIHPs.
Right, and this is why it can't work that way. Because a nonprofit entity cannot satisfy 2A for SUD services. The definition of department designated community mental health entity under 1100A subpart 24 is a CMH in one of its various forms or a CMH formed regional entity. And so there is no way for any other bidder to comply with the terms of the RFP as it is if they have to also comply with 2A of the mental health code, because nonprofits can't do that, public entities that are not CMHs or regional entities can't do that, and nor can a university do that. In
Just to be
fact,
clear, to use a university as an example, it can't pair with one of these CMHSPs to provide services. That's not going to work.
right, because 1287 requires the department designated community mental health entity to establish this SUD policy oversight board, which has a whole host of random funding streams, liquor tax, block grants, Medicaid. But what ties it all together is that board's role, as Joseph Sedlock testified, is to advise on all expenditures relating to SUD services, including how Medicaid funds are used for
But just
that.
to be clear about that, if you're right about that, and it is that strict, that's really a straitjacket in terms of the MDHHS's opportunity to restructure this entire system, right? Because if they have bidding to be the PIHPs for these super regions, everybody in the universe is excluded except for a properly formed PIHP or a CMHSP, right?
Under that scenario, two statements, Your Honor. First, an individual CMHSP under the RFP would not be eligible because they can't perform services outside their geographic area.
Right, across the super region.
Right. So you would have to have a regional entity formed. And I believe this goes back to our October 9th hearing. Right.
What if no regional entities are formed for these super regions? Then the list of eligible bidders, in your view, in these super regions is the null set. Nobody can bid.
And this is why the process has always been cooperative to date, and why we remain willing and eager to engage in that cooperative process, because the way the code is structured requires these entities.
Okay.
So, but as it goes to remedy, overall, Marissa Gove testified that the notice of deficiency is a limited remedy for limited items. And,
Right, right. I mean,
and
right.
so,
In a very long document, not everything's going to be perfect. And you don't want to create a situation where any small defect identified by anybody blows the process up and starts it over again.
absolutely. And that's the point of the severability provision.
Right.
Because the severability provision says you can sever a part, and two parts I think are interesting in this severability provision. The first is that the parties will agree on new language. Right now, there's no other party to agree.
I understand.
The second issue with this severability provision is whatever that new language is, still has to meet the same objectives and purpose of the RFP. That goes to the scope. And so you can't change something outside the scope of the RFP and just sever that. And so that's where, that's where we think the only outcome here is a reissuance or a pullback. That said, we understand that we'll take them at their word that they comply if the court issues a declaration that this RFP is fundamentally flawed and what it requires goes outside, and the changes would require it to go outside those core, that core scope. At that point, we think the remedy is clear, but DTMB can exercise that discretion.
All right. So in other words, as I'm sure you can tell, I am very uncomfortable writing a declaratory order that says that they have to pull back in this circumstance.
Right, because I can understand that being construed as effectively an injunction.
Right. Exactly.
And I understand the court's reluctance there, but I think the court can stop short and just say, this RFP is fundamentally flawed. And those fundamental flaws go to the core architecture of the RFP and how it's set up. And here's how I view this. You guys can figure this out and come back if you have another problem. We're not strangers.
I got it. Thank you, Mr. Marchand.
Thank you, Your Honor.
And you'll
Do you
get
have
another-
any other
No,
questions?
you'll get another chance to.
Okay, thank you.
You've said an awful lot that I'm sure Ms. Service would like to respond to. So we'll wait for her comments and then you can clean it up at the back end. Mr. Cook.
Thank you.
And before we get into your argument, you are exclusively advocating on behalf of the CMHSPs, right? You're not here to make any points on behalf of the PIHPs?
And we have one county as a, as a
Right,
plaintiff.
but your
it's-
clients are all CMHSPs.
That's correct.
Right.
That is correct. It's not,
And as I'm sure you can tell, my biggest concern is the CMHSP. So it's not as if you're not in the heartland of my concern, but.
yes. Well, thank you very much, Your Honor. And before I start, I would like to thank you for your, how gracious you were in giving your time to us and allowing a very interesting but different sort of hearing, if we will. And we feel, my clients would like to thank you. We feel that you've done an exceptional job in reviewing this and being expeditious in your rulings and comments.
Thank you. This is a very important case.
It is. It's very important. And I think we all should have the same goal. And I find it curious, though, that we perceive the way we get to that goal so different. And our goal is really to make sure that the most vulnerable in our society are protected. That's an obligation we have. We did a little bit of history in our briefs that we submitted to the court about how this system developed. It didn't develop overnight. It wasn't the product of an RFP that was being issued by, an administrative agency.
Right.
It was a development over time where we wanted to move those compromised individuals who are so vulnerable out of institutions and back into a community setting, back into a county setting. And since 1974, the mental health code has been devised so that we move these people back to where they have their families and their friends and their connections, and we make the counties responsible for taking care of these folks. And the mental health code was drafted with that in mind. And it also sets forth the ways in which that can occur. And the central way throughout the mental health code in which that occurs is through the community mental health program. If the county elects to set up a community mental health program, which they have done in this case, and all my clients are similarly situated in that regard, then they have to provide a full array of services to compromised individuals, to the most vulnerable. It's not just you serve them based on the employees you have and the different methodologies that you have within your own organization. You have to provide a network of services that are needed.
Right, and just to be clear, that sort of local control model, in your view, I assume requires the ability to enter into financial contracts.
100%. And the courts are identified this. I've heard this talk about
Non-financial.
non-financial contracts. What is a non-financial contract? I mean, it's unenforceable, number one. And number two, I think we've heard testimony, and we did present testimony in this case for the court's consideration. And I didn't really hear any testimony or evidence that contradicted what Mr. Johnston said from the stand. And that is, we have an obligation to do this, and the only way we can fulfill that with outside providers is through contract. The mental health code also requires us to have a contract with a community hospital where we can send these people in times of distress, in times of where these folks need some sort of admission, voluntary or involuntary. We have to have a contract with that hospital where we guarantee that they're going to get paid.
Right, and I'm glad you brought that particular problem up, because it seems to me that the most serious situation where this is going to create some tension is when somebody appears who needs to be involuntarily committed, because you have somebody you can't communicate with about their sources of funding. There's no way a CMHSP can provide all the services that somebody who's involuntarily committed needs. So both with regard to the ability to enter into financial contracts and the ability to serve as something more than a provider, I think the most acute example of a problem there is with involuntary commitments, right?
Exactly right. The court has identified one of the central issues that are going to be detrimentally impacted, negatively impacted, should the architecture of this RFP be implemented. And that is, it would completely strip us of our ability to react expeditiously, timely.
Right. I mean, there are statutory requirements for involuntary commitment that things need to happen within 24 hours.
That's correct.
There's no time, I don't think, for PHP to engage with a provider, whether it's a hospital or a psychiatrist or whatever the need is, to get the certifications and everything that are required for an involuntary commitment.
Exactly correct. And if all we're doing is the pre-admission screening and we say this person needs to be involuntarily admitted and that's it, and then what happens? What the deputy sheriff has brought this person to our facility. We do this pre-admission screening and they say, well, he needs to be involuntarily admitted, and that's all we can do. That's how I view this RFP structure. If we cannot contract and cannot hold contracts with providers, with hospitals, then how are we going to be able to effectuate that immediacy of that necessary remedy? And I think that's not only critical in that scenario, but it runs throughout the different sections of the mental health code that we brought to the court's attention yesterday.
Right. I don't mean to give short shrift to the other concerns you've raised. I mean, obviously, I recognize the SUD services. All of that is an essential component of this entire Medicaid mental health system. But involuntary commitment to me is where it seems especially unworkable to do what the RFP contemplates.
We concur. Absolutely. 100%. Your Honor. And I think that the objective of the department is also set forth in the mental health code. And the objective of the department is to support us when we have expressed a willingness and a capacity to participate in community mental health services. And so to support us, they have to comply with what's in the code. What's in the code is we're allowed to contract to provide this array of services. What's in the code is that we also have the financial ability to do this. And the way that this financial structure has worked out over the last 50 years is that we have funds that come from the state. We have general fund money that comes from the state, and now we have Medicaid money that comes from the state.
Well, answer Ms. Service's concern about this inherent conflict where CMHSPs serve as both payer and provider.
Well, I think that conflict is a red herring because, number one, we're a governmental entity. So we are subject to the
Public
FOIA.
trust obligation.
There's a public trust obligation. We're also subject to disclosure. We're audited. We don't make money. We're not a profit generating situation. We have the funds that we need to provide the network array of services required under the mental health code. And as Mr. Marchand explained, there's a cost settlement piece. So if we don't use all of those funds, they're returned to the state. And we've heard testimony throughout the proceeding that particularly my clients are 85 to 95% reliant on Medicaid funding. That is the biggest bucket of money that they have.
Right. And I think they're also reliant on the capitated payment system.
Absolutely 100% reliant on that, because if you take away those capitated payments, what are we left with? Fee for service situation where we're a provider, where we submit bills to this PIHP, but then we're also required to do all of these other services. And how do we do all of these other services? What's it going to look like after this RFP is implemented, if it ever is implemented, as far as what's left for our community mental health agencies?
And I quickly looked through the statutes last night. I mean, for example, recipient rights, you have to have a recipient rights officer, you have to conduct investigations, you have to do all sorts of other things because that's the fail safe in case some other provider is doing things that are untoward, right?
That's exactly right. And there's very specific deadlines and timing for all of those things. And in order to get a provider who's not within our own employment network to respond to recipient rights, you have to have them under contract. You have to have these outside providers under contract so you
Are
can
there
require.
actually terms in the contract that require them to participate
Yes.
in some sort of investigation about
Yes, there are.
recipient rights? That's what I figured there were
Yes,
provisions.
they are. And another term in that contract is we agree to pay you for the services you provide. That's consideration that allows us to require them to participate in the recipient rights investigation. So, and that's a very complex piece of business, and it's a great benefit for those people who are in situations where they're not either receiving the proper benefits, they've been abused or neglected. Those providers aren't providing the services that they agreed to provide.
Right.
Those are the things that we need to make sure, not just that we are providing a network array of services that are consistent with the needs of the beneficiary, but they're being done properly.
Let me ask you this. Is it feasible first, and then is it consistent with Michigan law that these PIHPs and these super regions could conduct the sort of recipient rights investigations that are traditionally done by the CMHSPs?
I think it's inconsistent, number one, with the mental health code, which gives us that specific responsibility.
Right, I thought you were going to say that.
And it's not feasible. Imagine how that would be conducted. So if we're just doing pre-screening, then we have no further oversight responsibility with respect to that beneficiary who's from our community, who's from our county. And we say, well, they need to be inpatients at a hospital somewhere that the PIHP has a contract with. So we refer them to the PIHP. Let's assume for a minute that they're set up similar to us where there's 24/7 operation going on, where we can get a hold of somebody over at wherever they be 150 miles away from us and say, this person needs to go into the hospital. You need to do the certification. You need to follow through on this. And then that's it. That's where they're left. So let's say, for instance, that they don't follow through and that recipient ends up back in our county. What's our power? What's our authority to find out about this? What went wrong?
Right.
If we say, well, right now we've got a recipient rights officer here and the recipient rights officer is calling the PHP saying what happened, what went on. They have no obligation to us to disclose anything. Plus they have health records that are now based on HIPAA. They are guarded internal to the agency.
So the providers in a practical sense now would be responsive only to the PIHPs.
Correct.
They can just give you the stiff arm.
Yeah, if the PIHPs follow through and require them by some contract, I guess, that they have to participate in recipient rights with the PIHP. We don't have the ability to be part of that. That's
You're a
part of
stranger to that entire
we're
relationship.
strangers to that contract. We're a stranger, and it's a violation of the mental health code. So that whole process that's been established by the legislature to guarantee the recipient's rights is although the mental health code puts it on our backs, we have no ability to follow through on that. And so those are the two things that the courts pointed out as far as involuntary admissions and recipient rights are critical features of the mental health code. And so we look at this RFP and speaking a little bit about the remedy, we find that it'd be totally unworkable under the provisions of the mental health code. And not only that, it would decimate the funding stream, the way that's now locked down with the PHIP would decimate the CMHs who have expressed the willingness and capacity to provide this array of services.
Right, the capitated payments end to the CMHSPs. Everything has to flow through the PIHPs, and there's no obligation that they give you capitated payments.
There's no obligation to provide us with capitated payments, even though apparently it still remains under the code. We have this requirement to do this needs assessment for the county on an annual basis.
Right.
And how would we even do a needs assessment if we cannot go to the providers who are providing the services for the beneficiary and say, all right, what are you doing? Show us your electronic health record. Show us how many people are you servicing? What's their current status? We have no way to track that now. If you bifurcate our duties that are under the mental health code and provide them to some PIHP entity. So those would be very problematic things for us to deal with respect to our obligation under the code to provide these services. So, I mean, I think when the court looks at this, and I understand the court's reluctance to step over just a declaratory judgment as far as this RFP is concerned, but I feel that in this scenario, the department is trying to legislate by administrative fiat. They're doing things that are so contrary to the mental health code that they're stepping in the shoes of the legislature. If the department wants this to happen and wants to have a different structure for the mental health code and the delivery of services, go back to the legislature. That's legislation. If you are going to try to change the purview of the mental health code, and we've shown the court, I think, about 20 sections where it requires us to be contract, or requires us to provide this network array of services, recipient rights, voluntary admissions, involuntary admissions, those kinds of things. Well, then take it back to the legislature and see if you can change it into some sort of privatized model. I don't think you can do it by simply pulling away our ability to contract and pulling away our capitated payments and saying we're going to do that in some other way. And Your Honor, we promise that we'll contract around these problems at some later date. I think that is not an answer to the court's inquiries regarding any sort of legality of the RFP.
Thank you, Mr. Griffin.
Thank you.
Okay, Ms. Service, you can talk about anything you want. There was an awful lot out there to address. I don't mean to suggest you need to address it all, but if you don't mind, can you start with this? If I find that there's incompatibility between the RFP and Michigan law, you can no doubt feel my reluctance to enter an order that would require pullback. Tell me how you envision the process will work if I issue a declaratory judgment identifying some incompatibility between the RFP and Michigan law. Will that be the province of DTMB to sort out, or will that be the MDHHS that will have to sort it out, or would the two act in concert with one another? Because I think Mr. Marchand did a nice job of explaining what Ms. Gove testified to, which is they have several options at their disposal. Maybe one of them is not workable here because there's no way to work out changes. But I think we have three options here. And you can tell that at least in the first instance, I would prefer that an agency make that determination.
That's for good reason. Under MCL 18.1261 sub 2, that gives DTMB the remedy or the discretion to run the procurement process, canceling and all of that list. That is within DTMB's discretion. So when we go back, go ahead.
Can I stop you for just a second? And I don't mean to cast aspersions by suggesting the other side of it, but is DTMB, if you will, the honest broker in this operation? Presumably, if a department goes to DTMB to have an RFP issued, the department has a strong vested interest in getting the outcome it wants. But if DTMB is an independent arm taking a look at the process and will make a considered decision about what the appropriate remedy is, Is that the function of DTMB
That's,
as it operates?
it is, because what DTMB does is they have a central procurement office that runs certain state procurements. So of course, the agency requesting the RFP, in this case DHHS, worked with DTMB in writing the terms and whatnot. And DTMB's role, though, was on making sure things aligned with the procurement laws and requirements, whereas DHHS had the program knowledge.
Right. I mean, think of it, I guess, what I'm trying to envision is whether it's a sort of relationship you have like between a lawyer and a client, where the client can have crazy ideas. I'm not suggesting MDHHS has crazy ideas, but the client often has crazy ideas, and it's the lawyer's job to tell the client, okay, that's a crazy idea and we're not doing that. Does DTM serve that sort of role when it comes to writing and amending and pulling back RFPs?
Yes, and that's because of that statute, and it references the department, and in that statute, it's DTMB. So if DHHS said we're keeping it, it would still be under the statute DTMB's discretion. So by my view, yes, that would be essentially a trump card over DHHS if they said that.
Okay, that's fine. And that helps a lot because I'm always trying not to extend my power as a judge beyond where it should go. And there are some things that I think that agencies have to decide, but I don't want to get stuck in a spin cycle here where essentially there's just a little window dressing and then they're back in front of me because I've retained jurisdiction and off we go again.
Right, and as Ms. Gove testified to, that other option, that notice of deficiency, that's essentially the only other option at this point. What she had testified to on Monday was that they can do the notice of deficiency for things within the scope of the RFP. And then in this case, she said the scope of the RFP is essentially like Medicaid, PHIP type functions. So I'm not standing here saying that DTMB could not look at this whole thing and use, their discretion to say it can or it can't be this notice of deficiency. That will be up to them. We have to see what your ruling is first, and
Sure.
that's going to obviously inform the next steps here. So that would be, I think, the appropriate remedy. If the court finds that something here does not conform with the RFP, issue a declaratory judgment on very specific terms so everybody knows the game going
Right.
forward.
Right. In other words, the list should be exhaustive, not illustrative, because an
Please.
illustrative list doesn't help you.
Exactly. And I think both sides here really could use some finality and some direction.
Look, if there's one thing that I know, it's that we need to get this done sooner rather than later.
Yes. In terms of the suggestion that Mr. Marchand made for mediation, I do want to address that. Again, for the reasons I just said, this is purely within DTMB's decision under the statute. We very likely would not be supportive of mediation, and here's why. And I know the court is considering exhibits that the parties attached to our briefs, and in our December 5th brief, we attached some meeting minute notes from the board of Region 10 PIHP, which is one of the plaintiffs. And in those notes, they said something about, the goal is to delay or stop the RFP. Mediation would just be open season to try to delay this RFP.
Well, and if I could give you some comfort in that, I'm ordinarily a huge advocate of mediation, but in this situation, I don't even know who all has to be in the room if there's a mediation. That's the difficulty. I mean, it's not as if I can just order the parties in this case to mediation and be satisfied that all voices are heard. I mean, who speaks for the people who bid for the PIHP contracts? Who speaks for the providers who are not parties?
And the
So-
beneficiaries. Yeah.
Right. I mean, right. Look, as far as I'm concerned, I would love to have a mediated resolution of this, but I just don't see any way that I can order mediation.
A few other things I wanted to address, I guess along those lines while we're talking about remedies before I jump to the merits. If this court issues a declaratory ruling saying these specific terms violate the mental health code, and then the state goes back to the drawing board, figures out what they are going to do, and in the meantime, the court retains jurisdiction. What we would ask the court for is a stay of the case, essentially no more discovery, no more motion practice. Let's let the state use their time to actually try to fix this if it needs fixing.
Right, and I think that's wise because if the state is trying to address a problem I've identified, the last thing it needs is further developments on the ground in this litigation.
Yes.
I agree with you on that. What I don't want to do, though, is render some sort of final judgment that's going to prompt somebody to have to file a new lawsuit. That's going to take up so much time.
Yeah, that, as I said earlier, that would be our preference too. I think that's a great resolution here if that's where the court goes. On the merits, just for the record, a few comments. I know Mr. Marchand said that the behavioral health waiver was renewed by CMS. Ms. Asman testified yesterday that that waiver is on only a 1-year extension, not a full renewal.
Right.
Again, just saying a few things here for the record. One of the things that Ms. Osmond testified to is the need for transparency in the system and learning what it is that CMHSPs are baking into their cost for service. I heard Mr. Marchand and I believe Mr. Cook talk about, we're just paid for the services, but we saw some disparity in Exhibit A, however much weight you want to give it, that there is some disparity there. So the question is, what are they actually baking into that cost for service? That's what the RFP would accomplish, is by requiring more transparency with that process.
But I take it, and I think you've already conceded that Medicaid dollars can be used, at least to a limited extent, for administrative expenses, right?
They can, and what the difference is we need more transparency in knowing if those Medicaid dollars are being into the service cost as well.
Agreed. I understand what you're saying, right? If $2 for something go to the service and $15 go to administrative costs, that's not what anybody envisions.
That's right. Court asked a lot of questions about civil admissions. And again, I just want to be clear that that is not one of the non-delegable functions, the pre-admission screening.
Yep.
And that's all of those functions under 1409. So Mr. Cook said, well, it's just a screening, but there is a whole list of functions under 1409 that the CMHSPs would do.
Yep.
I think our briefing covers the rest. I appreciate your time.
Thank you very much. Thank you for everything, Ms. Curtis.
Thank you.
Mr. Marchand, and then Mr. Cook, and then we're finished.
Thank you, Your Honor. The first point I'd like to make is whether mediation is the workable solution or not, we still remain willing, if the state is ever willing to reengage, we remain willing to work this out. Even the existing PIHPs that were under the FY26 with the November 30th deadline, there are affidavits saying they'll just extend.
Right.
Everyone cares about the beneficiaries.
Right. It does not have to be mutually exclusive.
Correct.
In other words, there can be extension of services provided by the existing PIHPs while we get this sorted out.
Correct.
So you don't envision the doomsday scenario being inevitable.
I don't think, as long as there's a willingness on the other side of the V, it's not an inevitable. I don't think it's even close.
I think we can all agree that when we get to the end of this fiscal year, unless something happens between the parties, that we do hit the doomsday scenario, right?
Unless something happens, we have a hard cutoff at 9:30.
Right, and nothing can be done about it.
Then the question becomes, I think, whether any other obligations relating to continuity of care are implicated such that it can't be stopped. Yep.
Thank you.
I'm happy to address any additional questions the court may have.
This has been really, really well argued. I came out here with a lot of questions I needed answered. I think both sides have taken them on head on, which has been really helpful.
Thank you, Your Honor.
Thank you. Mr. Cook, last words.
Just briefly, Your Honor, I'm hoping we don't end up back in front of the court with ongoing arguments about the RFP and restructured RFP, and it's still going to be placed out there, and they're still going to try to deprive my clients of the capitated payments and things of that nature. But there was a mention about this exhibit that the state introduced.
Exhibit
this
A.
Exhibit A, yeah. And we were prepared to put on some proofs regarding Exhibit A, but we pulled up short on that simply because I think it's not central to the issues the court was looking at.
It really isn't. And I want to be clear about this, not only for all of you, but for the benefit of my colleagues in my day job on the Court of Appeals, that the reason that I've been taking all this testimony is not to resolve a summary disposition motion under C8 or C10. Instead, it's the injunctive declaratory portion of the case where I've got to decide how the four factors balance out: likelihood of success on the merits, the likelihood of irreparable harm, harm to third parties, and the effect on the public interest. So had this only been framed as a summary disposition motion with a competing request for relief under 2.116I2, we wouldn't have had this evidentiary hearing. Where I come down is where I came down the last time. You've made an extraordinarily effective showing of irreparable harm. So that factor balances significantly in your favor if I get to an injunctive order, even on declaratory relief. But I think ultimately the linchpin of that analysis is whether there's a likelihood of success on the merits. Because if you have no likelihood of success on the merits, you could suffer all the harm in the world, but I can't issue an injunctive order.
Agreed. Thank you, Your Honor.
Okay, thank you. Sorry,
All right.
I meant to come out and say that for the benefit of the Court of Appeals, and it will be explained in a footnote in the opinion, because they may wonder, wait a minute, summary disposition motion and an I-2 request, and you had 3 days of evidentiary hearing? What are you doing?
And then it was us, so.
Right.
So that's a problem.
So,
But in any event, the state talked about transparency we are the most transparent governmental entity, I believe, in the state of Michigan. We have audits, we have reports we do on a regular basis. And we're more than willing to allow any state auditor to come in. My clients have requested, some of my northern Michigan clients have requested the state to come out and look at their organization, follow them, see what we do, only to have that never followed through on. So if you want to talk about transparency, we're more than willing to give you whatever transparency you want within our organizations, if that's the reason why this RFP is being implemented. So I think when you talk about transparency, how transparent is some PHIP organization going to be if they are a private nonprofit or a non-governmental entity? There's so many checks and balances in a governmental entity that are not available in a private entity. So with that in mind, and based on my earlier comments, Your Honor, thank you so much.
thank you, Mr. Cook. Thank you, all of you. I have found this extraordinarily educational. When we started down this path a few months ago, I knew precious little about all of this. I've learned so much along the way, and I really appreciate everybody's efforts. I have indicated that I'm going to do my best to get this out as quickly as possible. Sometimes I overpromise and underdeliver on how quickly I can get something out, but I can tell you this is by far the most important case on my Court of Claims docket. It is priority one. There's priority 1A, which is the West Michigan Partnership for Children case, which has to come out too. But fortunately, there are two of us doing writing on these projects. And so my senior research attorney and I have already been consulting at length about it. So I will get you something as quickly as I possibly can. And I thank you very much. And I wish everybody a safe drive home. Please be careful out there. Thank you.
Thank you.
Thank
you.
Thank you.
Okay, thank you, Mr. Trudell. Really appreciate you.
You're welcome. Thank you.
Good job. Oh, boy, do I have 5 minutes. Yeah, what I'm going to do is I'm going to try to gather